and welcome to another episode of In the Know, Slate's election talk show. I am Mark Joseph Stern. I cover courts and the law for Slate, and I am joined today by the marvelous, the fantastic Leah Litman, dear friend of Slate, professor of law at the University of Michigan, and co-host of course, the beloved Strict Scrutiny podcast. Leah, welcome.
Thank you so much for having me, and thanks for the promotion, since I'm actually an assistant professor of law, but I'll take it.
Yeah, you know, I just mentally edited out the assistant when I was reading the script because I feel like you just deserve all of the titles that I can give. So, look, we're in the middle of some confirmation hearings right now. They're not going very well. How badly are they going if you are a progressive and you are really frightened of Amy Coney Barrett and the last thing you want is a 6-3 conservative majority on the Supreme Court?
They are going pretty poorly as far as the Democrats launching a united, coordinated campaign in order to effectively communicate their concerns with this nomination and the irregularity of the nomination and process. They're also going somewhat poorly in the Democrats effectively communicating a message about the substantive concerns with the nomination. What they are doing well, however, is putting on a masterclass in why the Democrats have been losing on the issue of courts. You saw opening statements and opening questions from Senator Dianne Feinstein in which she was absolutely unable to communicate the sheer irregularity and abnormality of this entire confirmation process. And that was very much on display. So it is a reminder to the Democratic constituency that their elected leaders have not done enough for the courts, and that they need to convince their elected leaders to do a better job on that.
Right. Okay. So Democrats are bad at courts. They're bad at judges. They're bad at all of this stuff. We know that. They aren't getting better. We should be frightened by that. That's a good top line for me. Let's talk about some of the particular reasons why we should be so frightened. Okay, let's specifically talk about voting rights and election law. And I know that I am periodically freezing, and I apologize for that. Xfinity has been meddling with what I consider to be our political process and elections by preventing my internet from working stably today. They're basically the Russians. Okay, so early this morning, or maybe last night, the U.S. Fifth Circuit Court of Appeals upheld the Texas governor's decision to remove all but one ballot box from every county in Texas, even if they are huge and there are lots of millions of people living there. It was a 3-0 decision, right? And all three of the judges in the majority were appointed by Donald Trump. How does that decision kind of give us a preview of what's going to come in the next couple of months and years if Barrett is confirmed to the court as far as voting rights goes?
What it perfectly encapsulates is why the Democrats should not just be focusing on how a Republican-controlled judiciary will prevent Democrats from implementing their agenda, but will instead ensure minority political rule by entrenching Republicans' political power. Republican-appointed judges are allowing Republican legislators and Republican governors to make voting harder, particularly during the pandemic. This is just one example of that phenomenon. I'm sure we're going to discuss others, but really across the board, this remains true. And it's true not just with respect to voting rights, but there are also ongoing challenges to, for example, whether states have to count non-citizens in apportionment schemes in order to draw state legislative districts. That's just another issue that Republicans could use to further entrench, predominantly white, predominantly rural political power at the expense of majority political rule. And this Texas decision you referenced is another. Do we want to go into the merits? The merits are a little embarrassing.
No, do the merits, actually. Do the merits, yeah.
Okay. So, listeners or viewers might know that Texas Governor Greg Abbott issued an order declaring that the number of drop boxes in each county, and particularly Harris County, was going to be reduced to one. That is, one drop box for a major metropolitan area that includes Houston. If you think that one drop box is sufficient to count the number of absentee ballots, that's just pretty wild. He instituted this change, obviously, a month before the election. The Supreme Court has adopted this principle known as the Purcell principle, under which you're not supposed to interfere with election rules too close to an election, lest you confuse the voters. Obviously, the U.S. Court of Appeals for the Fifth Circuit didn't care about that, and they upheld the order on the ground that it didn't actually abridge anyone's right to vote, because you still technically could vote. It just might be impossible to do so and prohibitively difficult to access the one drop box in your entire county if that drop box wasn't overflowing with ballots. Even more ridiculously, the panel claimed that this was somehow equal treatment because every county received one drop box, ignoring the fact that, of course, different counties have wildly different numbers of people in them. So it's a pretty outlandish decision that will have dramatic consequences for a state that is, turning purpler every year. And it's another example of, again, how Republican appointed and Republican controlled courts enable minority political rule, even aside from whether they will allow Democrats to enact a Democratic agenda in the event that Democrats are actually able to win elections.
Right. And so on that topic, the Supreme Court recently agreed to hear two issues regarding this Voting Rights Act case out of Arizona, right? I was wondering if you could talk a little bit about that case and what's at stake here, because I think most Americans understand that the Supreme Court gutted the Voting Rights Act in part in 2013, but now the court is sort of placing on the chopping block the remnants, the vestiges of the law, right?
Yes. So when the Supreme Court dismantled Section 5 of the Voting Rights Act in Shelby County versus Holder, the provision they dismantled was known as the preclearance regime that required certain states to obtain federal approval before enacting any changes to their election laws. And one of the reasons why the Supreme Court maintained that preclearance regime was no longer necessary is because the Voting Rights Act contained this other provision, Section 2, that prohibits state laws that either intentionally or in their effect disadvantage voters of color. And what the Supreme Court said is look, you don't have to require states to get preclearance, because if they actually adopt voting restrictions that disadvantage voters of color, then Section 2 will prevent them from doing so. In this Arizona case, the Supreme Court granted, it involves a challenge to two Arizona laws, one that prohibits persons who were not the voter or an election official from dropping off a person's ballot. And the second prohibits the counting of votes that are accidentally cast in the wrong precinct. The U.S. Court of Appeals for the Ninth Circuit determined that these voting rules disproportionately disadvantage voters of color, and that one of them actually intentionally disadvantaged voters of color. And what this case really presents is the continued vitality of Section 2 of the Voting Rights Act, because, Arizona is not asking the Supreme Court to declare unconstitutional Section 2 of the Voting Rights Act. But what it is asking the court to do is to weaken Section 2 so it is practically unenforceable. The state is essentially asking the court to say that states don't have to really prove that their state laws advance a legitimate purpose or that they contain any real benefit. This is part of a complex doctrine called Anderson-Burdick balancing. And it also presents a question about whether Section 2 applies to restrictions on votes rather than redistricting. And so either approach the Supreme Court takes to rule for Arizona could dramatically cut back the protections that Section 2 offers for voting rights and civil rights.
How would you forecast Amy Coney Barrett would vote in this VRA case if she is seated by the time the court hears it?
I predict she would vote with Arizona. And I say that based on the votes that she has cast as a judge on the U.S. Court of Appeals for the Seventh Circuit. In her decision invalidating, or in her opinion, in which she would have invalidated restrictions on persons with felony convictions' ability to own guns, she went out of her way to contrast the Second Amendment right to bear arms with the right to vote, which she characterized as not an individual right and as a civic right limited to virtuous citizens. Someone who does not believe believe that the Constitution actually protects, individuals' right to vote is much more likely to allow states to enact restrictive voting laws. And you add to that her decisions in which she discounted claims of racial discrimination. So, for example, finding that an employer's use of the N-word did not constitute illegal racial discrimination or racial harassment, or in which she declined to rehear a decision in which an employer sent all Black workers to primarily Black areas of town. And she has extremely high thresholds for what constitutes racial discrimination, coupled with a view that voting is not an individual right. And you add that to the fact that she worked on the Bush team in the Bush versus Gore litigation, and I'm not particularly optimistic about her vote in the Voting Rights Act case.
Right. And then just to make it really clear, let's talk a little bit about, how Justice Ginsburg approached these voting rights cases and compare that to a potential Justice Barrett, right? What was Justice Ginsburg's approach to the right to vote in the United States?
Justice Ginsburg was extremely protective of the right to vote. She recognized that it was a product of hard-fought gains of civil rights movements over the course of the century. She became known as the notorious RBG because of her dissent in Shelby County versus Holder, when the Supreme Court gutted Section 5 of the Voting Rights Act. She infamously or famously wrote that getting rid of the preclearance regime was like throwing out your umbrella in a rainstorm because you're not getting wet. And she also predicted and noted that states had increasingly enacted what she described as second-generation barriers to voting, facially neutral laws that didn't explicitly mention race, but nonetheless made it more difficult to vote, primarily for voters of color. And she was right. Just today, there came out a study in which it was found that the amount of time that voters wait in order to vote is correlated with race. That is, Black voters wait on average more than an hour to vote at a much higher rate than white voters do.
And so a lot of these sort of Jim Crow 2.0 laws, a lot of them are pretty blatant, right? We've seen these mass poll closures in minority communities, right? We can talk about Georgia, where we're seeing how long 12-hour lines in Georgia, right, for early voting. And I recognize that this is early voting. It's not election day yet. But, if you look at the polls that Georgia has shuttered over the last few years, they are disproportionately in Black communities. Those are the kinds of actions that would have been stopped under preclearance, right?
Yes, absolutely.
And so it just seems to me that if Democrats had maybe any kind of savvy understanding of how politics works, every time people are disenfranchised by these laws that were enabled by Shelby County, maybe shouldn't they be blaming the Supreme Court for allowing this to happen? I mean, why is it that whenever we see Georgia or Florida or Alabama, Texas engaging in these kinds of voter suppression routines, we have federal courts for a reason. They're supposed to be a guardian of our liberty. If you had to grade the courts on voting rights over the last 10 years or so, I mean, would you even spare them like a D+?
It depends if I'm feeling generous, maybe how much chocolate or wine I've eaten in the last 24 hours. They have not been great on voting rights. And I think you're exactly right that Democrats have not done an effective job making the Supreme Court own modern day voter suppression. You think about people like Josh Hawley or Ted Cruz who take to the Senate floor and give impassioned speeches after the Supreme Court holds that federal law prohibits employers from discriminating against LGBT employees. And Democrats aren't doing the same when all of these second wave vote restrictions pop up in the states. They're not taking to the Senate floor and making impassioned speeches about the consequences of the Supreme Court's decision in Shelby County versus Holder. So their constituents and Democratic voters, I think, really need to force them to do so.
Okay, thank you. I appreciate just this sanity check because it does make me sometimes feel like I am losing my mind. Let's talk about another one of these second wave restrictions, Florida's poll tax. I am from Florida. I was so proud of my home state in November of 2018 when nearly 65% of voters approved a constitutional amendment that allowed people with felony convictions to vote once they have finished their sentence. And we just saw a study come out that shows about 8% of former felons in Florida have been able to register to vote under that law. Why? Because Republicans immediately got to work gutting it, and the 11th Circuit Court of Appeals upheld their sabotage, right? Can you talk a little bit about the background here and why there is suddenly another poll tax in the state of Florida in the year 2020?
Yes, absolutely. So this decision also illustrates, not only how Republican-controlled courts will prevent democratically enacted initiatives and agendas from going into effect, but also how they will blunt the effect of pro-democracy agendas. So you mentioned the Florida constitutional amendment that re-enfranchised persons with felony convictions. After that happened, the Florida legislature, together with the Florida Supreme Court, adopted and upheld a scheme that prohibited persons from regaining their right to vote if they had any outstanding fines and fees. Just to be clear, fines and fees do not mean restitution. That is, it doesn't include money that a court said you have to pay in order to make, your victims whole or as part of your sentence. Rather, fines and fees are things that people accumulate simply by virtue of going through the court system or having been imprisoned. And they can be extremely high and prohibitively difficult for people to pay off. So after Florida enacted that scheme, I think one of the cruelest provisions in the scheme was the fact that Florida does not have a centralized system for informing people how much debt they actually owe. That is, what Florida did is it told people you have to pay off all your fines and fees, but by the way, we can't tell you how many fines and fees you actually owe. That made it additionally difficult for people to pay off their fines and fees. And Florida also makes it a felony to vote without legal authorization. So you were subjecting people to a possible additional felony conviction if they voted without telling them how to actually regain their right to vote. So this modification of the state constitutional amendment was challenged, and the district court upheld several constitutional challenges to the scheme, including a due process challenge, finding that because Florida failed to notify people of the amount that they owed in fines and fees, the scheme was actually unconstitutionally void for vagueness and subjecting them to additional criminal punishment without being sufficiently clear, and also burdening their right to vote, again, without sufficient clarity. The district court also found that it constituted an unlawful poll tax, as you suggested, saying that you can't require people essentially to pay in order to vote. And the U.S. Supreme Court, or the U.S. Court of Appeals for the 11th Circuit initially agreed with that ruling, but then the full 11th Circuit, that is every judge on the court, elected to take that ruling en banc, revisit it before the entire court, and the U.S. Supreme Court allowed them to do so over a dissent by Justice Sotomayor, joined by several of the other more liberal justices. And so because of that ruling, there are nearly 1 million Floridians who are potentially disenfranchised. This is a state that Donald Trump won by much less than 1 million votes. And so that could be really significant in the upcoming election.
Right. And we should note, I think, that the 11th Circuit decision upholding this poll tax was 6-4, and 5 of the judges in the majority were appointed by Donald Trump, and the 6th was on Donald Trump's Supreme Court shortlist. So these are the kinds of rulings that I think we can expect from Trump nominees in general, and certainly from Amy Coney Barrett in the near future. Thank you for talking to me about Florida. I really love that state, but it breaks my heart every day. And I just, I feel like whenever the people of Florida try to do a good thing, the other crazy people of Florida come in and basically take a giant dump on their heads. And I was one of the people who really wanted a good thing to happen. I had faith in Florida for the first time in years in 2018 when this passed, and now that faith is all gone. It's like, I love the nature, I love the flamingos, I can never move back there, okay? Because they really hate, everyone who's not a Trumpy conservative in the legislature because of gerrymandering, right? Because of extreme partisanship. And I fear that Florida is a kind of model for the way that the federal government could go if Trump wins a second term, if Republicans are able to keep control. Just extreme marginalization of Democrats and of democracy, small d democracy, to the point that the government is choosing its own electorate, deciding who gets to vote for who will stay in power, right? So let's talk about the election. Let's talk about Donald Trump. There is currently a case pending before the Supreme Court as we speak about Pennsylvania and absentee ballots. Can you talk to us a little bit about that case and tell us what the stakes are?
Yes, so the Pennsylvania State Supreme Court held that under Pennsylvania state law, voters are allowed to drop off absentee ballots after Election Day, and they held that under Pennsylvania state law, votes will be counted even if they are received several days after election day. The Pennsylvania State Supreme Court also upheld the use of drop boxes to collect absentee ballots. So the Republican Party went to the U.S. Supreme Court asking the U.S. Supreme Court to put on hold that decision of the Pennsylvania State Supreme Court on the ground that the Pennsylvania State Supreme Court hadn't interpreted state election law, but had actually changed it in violation of the Elections Clause. This is, of course, eerily reminiscent of the theory that was advanced in Bush versus Gore, which was that the Florida State Supreme Court had altered the state's rules for counting ballots and that the Constitution required those rules to be set by the Florida legislature. And the U.S. Supreme Court has not acted on this petition yet. It has been holding it for quite some time now. And, we really could be expecting a decision any day. And it could be, again, I say many of these decisions could be really significant, but that's because they all could be. Pennsylvania is another state that could go for Biden or Trump and whose outcome could affect the winner of the 2020 election.
So let me just be really clear about this theory, because it seems so radical that I think a lot of people are not going to quite grasp it at first. So what Pennsylvania Republicans are arguing is that the state Supreme Court, which is the ultimate arbiter of state law, right, it violated the Constitution because it changed election law and only the legislature is allowed to do that. Does that mean that the governor is not allowed to have any kind of say in election law? Does it mean that if the voters choose Biden at the polls on November 3rd, that the legislature can step in and just overrule them and assign electors to Donald Trump anyway?
So I'm a federal courts professor, and I think that one of the things that is most striking about this theory that the Republicans are advancing is that they are asking a federal court here, the U.S. Supreme Court, to second guess a state Supreme Court's decision about state law. They're essentially saying the state Supreme Court got state law so wrong, it violated the federal Constitution. If they actually get the U.S. Supreme Court to accept that argument, then I do think it really does open the door for different challenges to how states are running their elections, because it allows any dissatisfied party, and I think it would sometimes be the Republican Party, who would be challenging governors and legislators or courts' attempts to expand voting rights in the franchise. And they would argue that effectively those governors or those courts got state law so wrong that they were violating the federal Constitution. I think that that is an extremely dangerous precedent to set. And I am waiting on pins and needles to see what the U.S. Supreme Court does.
So that's a theory that's similar to what Scalia, Thomas, and Rehnquist said in Bush v. Gore. Is that right?
Yes, exactly.
Okay. So basically the legislature calls the shots and everybody else can just go home. Okay. Very terrifying. Final issue. We've only got a few more minutes. I want to talk about the Department of Justice. And I'm not just setting up a joke for you, but, we have an attorney general who is actively undermining the legitimacy of this election. We have an attorney general who is making up fake examples of voter fraud in order to delegitimize absentee ballots, right? He's making up all this stuff about them being dumped into creeks and, mailmen getting bribed to pick that. It's all madness. It's like very hard to follow. I guess I'm just curious, we've had presidents with departments of justice, during election years in the past that weren't crazy, that didn't go mad. And because the DOJ has been so politicized under Trump, I think it's maybe important to talk a little bit about how unprecedented it is for Bill Barr to be joining Donald Trump in his effort to basically sabotage the integrity of the election.
Yeah, so this is another norm that the Trump administration has really bulldozed through. Previous Departments of Justice and attorneys general have thought that the DOJ should not be intervening, or not even intervening, but coming anywhere close to weighing in on the propriety of an election or election results. In addition to the statements that you mentioned, Bill Barr propping up unfounded conspiracy theories about voter fraud with respect to absentee ballots, he has also, altered department policy, essentially allowing federal officials to potentially intervene in, the state's conduct of elections if they are suspecting voter fraud. And they are just undermining, norm after norm. And this is one of the, most important ones, is allowing our elections to be conducted free of federal coercion and federally propagated conspiracy theories.
Right. And so basically the Department of Justice and Trump's personal lawyers, is there a difference at this stage?
Perhaps, in that we are paying the Department of Justice and not Trump's personal lawyers.
Okay.
But maybe I'm missing one.
Okay. That's a good answer. I have one last question after all of this doom and gloom that I'm hoping maybe will give us a little bit of optimism, but maybe not. Your call. How do you think this election, 2020 presidential election, will be remembered by history, by future historians? What do you think it will be remembered for?
I hope it is remembered for overwhelmingly high turnout, and turnout in favor of democracy.
Okay, got it. And if that doesn't happen, if everything goes wrong and Donald Trump claims victory on election night, even though he's losing, what is your plan B? Okay, because mine is to gather a bunch of Aperol and Prosecco and fizzy water and climb into the nearest nuclear bunker and stay there for 4 years. I want to hear yours.
My plan is, as I'm being hauled off to the gulags, to send out tweets like, I'm sure institutionalist Lindsey Graham will condemn this any second now.
Wow, that sounds like a great idea. I will be sure to save room for you in my bunker if that doesn't work. Leah, thank you so much for joining us, and thank you to everybody who watched at home. You were a terrific guest. This was a really fun show. Come back on Monday for another one. My colleague, Julia Craven, will be joined by Philip Agnew, co-founder of the Dream Defenders. This show is produced by Faith Smith and Britt Cooley, and from all of us at Slate, take care.